Yamamunya kwa baby wadofo no meba Ekosiisen dwumadiye so Tuesday afternoon, the 16th day of February 2021. Ekosiisen mrena san asubio yada sesene ne da edikan a wode wafidi na to ha 8 yen studios ewo Kokomlemle 355 Fanofa Street Kokomlemle here in Accra, and dia ha ena yewo edi dwumadiye fi bremo inti yaramase na nye Asempa FM so nko a yewo other affiliate radio stations across the length and breadth of Ghana inti ebia wono Tamale ena 8 ya yewo ABC radio ewo Tamale o Salaga yewo Can FM ewo Salaga oba Sunyani Storm FM uko Brekuma Grow FM uko Japekro Menida So FM oba Wenchi Ewiase FM ena Royal FM uko Akomadan Cruise FM Uchem Echo Offense yewo Time FM ewo ho Obuasi 14 wo PZ Radio Asante Achem Agogo Adansie FM uko Sekendi Takrade Aseda FM uko Bibieni Ochiame FM. And the stations are a fire in Jumedi no edoso across the length and breadth of Ghana. It will be a wubia and ubitimi etien. Meaning your saibons to from Yobia Mejoso. Check with the time, 19 minutes after 2. Our show is live from now till 6:30 p.m. into 4 hours, 30 minutes. Prime time radio. Ekosiisen is live and airborne. So please tell a friend to tell another friend to tune in to 94.7. On behalf of the production team, Dominic Kisi Yaboa, Nana Chumberema, Jackson Osei Tiamoa, Eric Opare, popularly known as DJ Ayo, and a Queen Star in Japan. That's the team behind Ekosiisen. Omai hene kwabana santen so boy chidom enti yamama kwaba esan edamwase. And then same go opponents, of course, would be in the Supreme Court. Now the Akosuo Court and then Yetimi de Munsem Abremu Joseph Akable will be joining me any moment from now. Now afe the Akosuo Court Yetimi ebiemu amamonso matemo ho as we are. We'll get onto the phone lines, speak to spokespersons from the main parties in this suit, from the petitioner and afe the second respondent. We'll be speaking to some private legal practitioners as well. Now, Yasha said the Nyoma ABC Ako. Area at 4 p.m. Would sit with the General Secretary of the NPP, Mr. John Buedu. Yabasha Nsembe Bre 90 minim. Wasama uhia John Buedu Ebusano. Ubetimi edi abrain. Your test line is 0546 382 287 0546 382 287. That's our test, our WhatsApp line actually. And if our messages never so brain na yenshe enkai emo. Any question for him? Oko Facebook same. Ubetimi the one semegu Facebook amayen on Twitter, on Instagram. Please let's stay interactive. Just be an active listener, not a passive one. Inti other messages neba ebe and de papa. Yetumi akan amount. Make us say Joseph Akable at na say ncheme na kwaba na ansa na no ya mo ye na boafo abaso a ansha na asem atoyen enti your sponsors ho asem na making sound of our time ewe Ekosiisen so Agbeve Herbal Center na Amponsa Ifa Pharmaceuticals na boa yemi de bremo me here asem segment nso Ecobank Ghana Awake Purified Drinking Water and a Rockstars Roofing Systems na boayen. Yeah, one-on-one interview session and interviews on trending issues so having insecticide spray and coil and napa foods and a HEPA plus mixture and ma apomodin ampa omonso boayen. Yeah, discussion segment DV so Franco Trading Enterprise phone papa fee TCL, the Creative Life, Dependable Herbal, Adom Malakio, Abejaso, and a Global Lighting Center Limited, Amonso Ebuaye. On the Yabom Raneka, Nkania Papa Fee, Nkania Papa Fee, Amonso Ekayabua for Nointi, Yaramunyanase for staying faithful to this brand. Many thanks for joining us. Ekosiisen is live and airborne. Joseph Akable, Mediema Nzemali. Akable, Kodie.
Better.
Akokenu
Yeah, okay.
I don't want them. I don't share any confess.
Oh, no, I can. Ubisa me question say. Second, Ubisa me say the same. And I may say, yeah. And I Ubisa me say, my sitting in muti sing. And I may say, me wo. Questions that Ubisa na me ya no pepe.
Maybe I will call there.
Yami adum.
Yeah, na nyame ase. Enra yetna sidi nkomo ama ye nyina ye hu se I think it was yesterday, right? Say Enra, Enra. And ani ye nyina ye hwe nim se and the Supreme Court had one ruling ebeba eventually panel on it na say and the president of the panel read out ruling no of the court. Highlights no when your copy of the written ruling no and I say my
Enyambai by any gusu ADHI and Saka.
Super. And highlights no of the ruling that is saying.
The kind court no or say the petitioner has not demonstrated that it intends to obtain evidence that has the potential to change the outcome of the case. Neither has it showed that such evidence was not obtainable earlier. And to say bia or bibia ujidi sanka asase of trial na wentumi enya na ujidi say ye ma okwan ma obi case na
na obetumi
enya efisa witness opese obegina adakani afi court na ka say there can also not be a need to seek clarification from this intended witness of the first respondent because this witness has not even testified. Agent mensa and say once na okaya in the course of application no okay, say questions be arise with regards to vote pardon and whether or not say or no instructed say rojo metu no pesa white in fear court so na.
That's true.
Or see where your witness are on testify and to mean kase yema okwan say un be case ne sana be ya be seek clarification if it's our witness no and I think to be or say the court once again emphasized the fact that the success of a petitioner's case is dependent on his evidence. Arguments raised by the petitioner is almost the same as those raised in the objection to the first respondent's decision not to testify.
Oh, okay.
Then there was a point about the fact that the EC chairperson or say or accounted to vindicate herself in terms of the work that she has done. The court in the response when they said the EC chairperson is not on trial.
Okay. And you're on the trial into that point, sir. It was said Obabe testified to account to the Ghanaian people. No, doesn't hold.
Yes.
Okay.
And the other court, no, a procedure say in the circumstances, no, a case has not been made to merit its exercising its discretion to allow the petitioner to open the case.
Reopen the case.
Into the main issues now, or stick it to by relying on the Canadian case and others, relates to the bit about the two conditions, first, say, obtaining some evidence, be a Philippa, and also demonstrated said, some evidence, available to, and this is evidence that has the potential to materially affect
case,
the outcome of the case.
Okay.
See, in the words of the Chief Justice, so this is evidence that if it was available at the start of the trial, it will change how the case will terminate eventually.
And I'll say, according to the court, petitioner na me improve sadie said they would need that evidence now materially be affect how our case nebeko. Okay. And the first threshold and also momiti. Second one was here then.
Or say about so the first so in terms of the two, one has to do with the evidence the fact say this is evidence opese obtain if witness who at the start of the trial
now
it was not possible for you to get then you have to again demonstrate that evidence has the potential
of affecting
materially affecting the outcome of the case. When I had two conditions now in fact obekaya essentially argument akotampa any just na maneuver making in fact akotampa was very emphatic on two conditions because can say application, even though say Omu created the impression say they are just seeking to reopen the case and subpoena the AC chairperson Omu said Omu separated the two issues. His argument then was that the court cannot separate the two issues because when you finished with your third witness, no one can will close the case. And this person will open the court has to be worried about why you want to open it. And in his opinion, it's a quest to adduce new
fresh evidence.
Which in his argument
who backdoor the new evidence
about there, then you need to meet that threshold.
Okay.
Demonstrating that this is evidence that was not available or you could not have obtained from the onset, and that this is evidence it has the potential to materially affect the outcome of the case.
Okay.
And then the main basis of court in the so say there was also a comment about this whole bit about the adverse witness issue now, Mr. Chikatakai. Okay, justice beside from the onset.
Or but in what capacity? Yeah.
But the court, by relying on the Black Dictionary, definition, the point of making is for such a witness, to be an adverse witness, this a witness, waba adakani.
Okay.
Then in testifying, the wakanu to me say it's not helping the case of the party or the buyer. Into saying in that instance, now we be say they should treat the witness as a hostile witness.
As a hostile witness.
But
when on testify,
it does not apply to.
Apply.
Into hono na obe kaya tama court ni we na chachikata kasano. The first point to make is or a surprise even though say evidence the act no hono, the court will rather rely on a dictionary for a definition of who an adverse witness is. But I mean, the court is entitled to do what they want.
Okay. Into for now, the court not dismiss the motion to seek to reopen the case of the petitioner. Court ato eno eguse omo meet the legal thresholds in the petitioner sorry can then what is next line of action
in open courts? Judges in Vienna Chachika Taibo court na mani say there are some series of applications. In fact, the Supreme Court on a quiet top some trouble for a good top na top already hunyama embra Chief Justice started so ready decision a member of the NDC's legal team Mr. Regista Maklo he say okita envelope kesiya brown envelope kesiya pa documents eguma or dash it out of court
almost as Muridian
or dash it out in the words of Chachiti Katanankasa or confirm it to court and say as at the time a court ni we no ka say oma file
review
of the court's February 11th ruling.
February 11th,
the court in the case said the first respondent can compelled to give evidence.
Easy anything means as well evidence. Ruling
on my file
review. Okay.
They have also filed for a stay of proceedings. And the Chief Justice Nebisa say, have they filed? And if they have filed, has the registrar given them a date?
Okay.
Because we're going through filing process for court when we are. It goes up to the registrar, who coincidentally was actually in the court at that time.
Okay.
Registrar never draw data over back court. And the end of the Obisa and say, so has the registrar given you a date? Then now his response was that his colleague just left while he was reading the decision to go and file, and that he's in the process of filing now. Subsequently, we have been told from the lawyers, to me, I file it.
Okay. Almost like a date, no.
And then information and maybe sir, we are still waiting for a response on that.
Not just they say train data registered for the hearing of the review application.
Sir Pepe.
But while at that, court directive say obi filing a written submission by Ochina and that's so
effective Chief Justice at the tail end of proceedings no science subium. Say they should go ahead and they can file whatever process they want to file. The court is a court of records, as he had said previously. I said they can file the processes that they want to file. Once a date is given, if it is given, the date is fixed for tomorrow, they'll come and deal with it. If it is for Thursday, they'll come and deal with it. But as it stands, the court order, it remains. I.e., by close of day tomorrow, also munya file written addresses. Then on Thursday, na mo beba be oral submissions on the written addresses.
Okay. Inti not just say and apart from review application, also petition and the lawyer indicate say on file stay of proceedings.
Proceedings, yes.
And no normal file.
Sana a indication or the man or say on file and so.
And no stay of proceedings.
Stay of proceedings no any have a review of the decision that
on 11th
they cannot compel the AC chairperson to testify.
In the stay of proceedings, not just say stay of proceedings, we file meaning say Ochina or more written submission, they might not submit.
That was the view now. I'm taking last time. I court Nini Anjo.
Court Nini Anjo.
I court in the car say so. My order, especially in the face of CI 99, which calls for an expeditious hearing.
Yeah.
Or say of my order now, you just have to obey the order. Then whatever steps you are taking, they're independent of order. Because those steps now we're taking, there will be an opportunity at court, about addressing those issues. Until now, in that instance, they are taking the view that because I'm not filing for a stay of proceedings, no filing for review, they thought that they shouldn't file.
They shouldn't file.
That day, no Bekaya not on later the Jinema. That is no boni Japan. I
mean, they might be forced to
impose sanctions, which could even lead to striking out of the whole petition entirely.
With the benefit of hindsight, they might not want to repeat some mistake, because once you file the stay of proceedings, it has to be granted you by the court. It won't mean that I'm filing mere so motu. Maybe some halt there was maybe until let's see how that would go. But 23 hours ago, Kujoana Nankoma is Ankoma posted on Facebook, or say the ex improviso rule applies to reopening a party's case in both criminal matters and civil matters. That and said now Joseph was say that something new, unexpected, sudden, unforeseen has arisen in the course of the defendant's evidence, which no human ingenuity could have foreseen and which need to be disproven or controverted. And I think when it's a legal threshold, it was a me immediate. And of course, court ne de can say, apart from that, evidence na unforeseen should be able to materially affect the case. And petitioners ninety me meet our threshold ninety and or Masaya dismiss this particular
unanimous 7-0.
We say 7-0. Wow. What it means is that so far interlocutory applications are abano, apart from the application to amend the original petition, and on a court granted that to the petitioner. Second application was to serve interrogatories, and on a 7-0.
7-0.
Third application a review of the decision to serve interrogatories, and it was a 9-0.
And before 9-0, there was a request to file additional arguments to support the review of the interrogatories. And then about 9-0 answer, review 9-0,
review 9-0, 7-0, 9-0, 9-0.
Then there was a request about the EC. In fact, inspection of documents. And also 7-0. Then the request about the objection to the EC deciding not to testify.
Decide not to testify.
And also 7-0.
And motion to reopen the petitioner's case, and also 7-0. And the train review of the
ruling on the EC's decision not to testify. And I know as we saw in the previous instance, two justices. In the previous instance, there was Justice Professor Henrietta Mensah Bones and Amadou Tanko and Abedjani. We don't know whether
the other two and I say different two now after the application for stay of proceedings will be heard. It's a court never grant here, then we would see. Those are the two outstanding applications. I hear how and also able to me. And it's so far throughout this trial, interlocutory applications are no petition and lose 7-0, 9-0, 7-0, 9-0. It's here how but and after court ni decision, court nankasa ka say omo adjourn to that and
Thursday. So indicate already now announces the case adjourned to Thursday into science is home. Say because the orders remain, it's more back Thursday into whatever process will be after say or filing they can go ahead and file that, but they are coming back on Thursday.
In the afternoon are the usual press conferences, a course.
And they know Jawumpa.
And then they Jawum. First team was petition and the team. Now almost saying
Dr. Ine say decision or say incorrect. Or say incorrect in law. And it's not supported by the position of the law the judges took. And it creates the impression that they had a predetermined outcome.
But that's a serious.
But eventually,
you no a predetermined outcome.
Eventually, full up questions. No, he went around the issue to still say that, I mean, as far as they are concerned, they don't think that this is a decision that is in the interest of justice and in the interest of Ghanaians who voted. And if it was the case that the NDC was seeking to just, Mr. Mama was seeking to just put across technicalities, and come insist to say easy chairperson and bra, but almost percent no crano, ebe day, and nipo bet me a casano crano, a year, Jen Mensa. No more, the say, or case now, more close, you know. A ironclad, a strong case. As it stands now, because the EC did not lead evidence now, their evidence has not been rebutted.
Yeah.
And they want to follow up, you be so almost say, and if it's not been rebutted now, and then why are you still bent on getting the EC number and answering a question? And the response no, and they say, no crano, they are in pursuit of truth in his own words. They are in the pursuit of truth. And the sound of crano said dead, you know. Omujidi say Ghana for be brain also. A percent of credit dead into no more cassette. Jen Mensa Ombran Bejina Dakani.
And for
now,
them,
the court is
Jen Mensa and Kwani bit me the no crenaba.
Because I don't know a returning officer for presidential elections. I don't know Bobo Abanasu. I don't know him coin of fast or calculate his results now. And who be here say court name who coin Ombran may testify.
Ombran may testify. Wow. And that's petitioners no point, no. And I think at that press conference, now you indicate he said they would file a review application of even and the ruling, and so you will see how that one would also pan out. Into your mumu you know, and second respondent team then so by now among so today.
The kind omu make comments on Dr. Ine comments regarding the predetermined outcome. I say they don't think that those comments were very fair to the panel, and as far as they are concerned, no, they knew that the petitioners were once again going to lose this one because arguments are petitioners making, in their opinion, were not supported by law, and it's no surprise that the court ruled in their favor and actually relied a lot on some of the cases that authorities are not putting across as part of the arguments. No, now, as the day goes on, no, as say NDC supporters, according to Kojo Ponkroma or Kasa on behalf of President Nesai, no, or as the day goes on, say NDC supporters no move, you no more share proceedings closely, or more means someone penny for no. They can more dad or say, obedient to me or more dinkunim, and after your mother back court, almost obedient to me and dinkunim. And I say, after the obedient to me and dinkunim, so meant to me improving after your more chasing Jen Mensa, case no more the back court, almost obedient 50% no, or Madano, no, Jen Mensa and Cassa, just a any case. So say, Mujidi say, yes, arguments now, a munye drew now, court a keep a botuguno, and who before no more they can't more can, and I don't munjini say petition an idea. Or any case,
any case. In the ruling of the court, no, as read out by the president of the panel, no, did they give an indication? And that's what we create impression. Be say in such trials, no, say petitioner, no, it to me is stating a case, a compelling case. The respondent will not have to even be compelled to step into the box, or more would come out of their own volition.
A point I'm making is say is the fact that a petitioner, the success of a petitioner's case is dependent on evidence or the bebano. And also in this particular instance, no, Omun demonstrated say not even allowing the compelling allowing them to reopen the case in order to subpoena someone. No, it will result in the words of the CJ or say not to testify will occasion a miscarriage of justice. I say omu exhibited that, and of course, Okoka say, "Sa further evidence no person would give you Jimenez on campo. Omu disclose it."
Okay.
And also, I'm Biomka say this inherent jurisdiction of the court omu say omu trigger.
Yeah.
Or say it's a very limited space. The court should not tamper it anyhow, unless there is an extraordinary circumstance. Because I say, if the court does not frown upon that, litigation will not end because the parties will always come in and make such requests, and so it's limited. I would say ultimately convince the court, no, and in the court's opinion, in order to convince them, no, when a requirements now also meeting now, you see, so now also once I went to me meeting it, and they went to me in case, because of that, no, a miscarriage of justice will be occasioned. Now, Dr. In any argument in response to that point, now Okan Abontin say, how would they be able to indicate the evidence if they've not even obtained the evidence yet? That was his argument.
Okay.
I say because evidence no more pen or more general Mensa or
And Umbenya, and according to Omono, Umbenya saw evidence through cross-examination.
And I now make a point and they say assassin they filed for admission of facts.
Yes.
When few easy for name few they filed for interrogatories or main few. Then they wanted to have a review of the interrogatories. They were told that cross-examination, after cross-examination, so Mensa say on back. So say at every 10 information on Muhiano is moved away one way or the other.
Wow. That's really interesting. Enti Ekosiisen ne higher sempa 94.7 FM. Safi na do afidie no atoha. Ye share Supreme Court decision on on the motion to seek the leave of the court to reopen the case of the petitioner. Some motion the Supreme Court admits in a unanimous ruling into 7-0 against the petitioner. And only in Komoa, many Joseph Akable and court correspondent AD. Very, very, very interesting outcome. And the press conferences also echo so our parties no everyone are doing Etuja. Also, what Jane Etra was saying, but more than say what the messages never bring 05463822287. Now, Yebesha Kai Amawe say Obi, looking at the behavior of the petitioner John Mahama, he is likely to go for a review after the final determination of this petition, Nana Hesse or Jerry. But that would be well within their right so to do. Enti Yebesha Sadi Anonso Ebisiako Abdul Karim, the political speaker from Wenchi Zango. He says the Supreme Court has been fair to the petitioner, Mr. John Mahama Pa. From day one, the petition was without merit, which the Supreme Court could have thrown out. Former President Mahama is only okay. Those are not fair. Ubia Bedidi is coming. Thank you for your message nonetheless. Ma mention other ones. Abawe say, Obi, good afternoon to you and your lovely team for the day. Obi, if I were to get the opportunity to meet my senior brother, His Excellency John Dramani Mahama, the former President of the Republic, I would humbly appeal to him to let this case go. He still has many years ahead of him to be able to contest another elections in Ghana, or for another word, he can continue as former president where he can still be taking on international assignment as a fine former president, while he continues to help his party to work towards the 2024 elections. My candid opinion, Obi, I will continue to campaign until Asempa gets an affiliate station in my region, the Upper East region, for us to benefit from your show. Asaki Awingobit, and on the way, Abba Asaki Awingobit. Thank you for your message. Good afternoon. Obi Justine Amenuvo is a star boy in this election petition hearing. The day he said his client will not mount the witness box, Chachu's preparation for cross-examination was dismantled from Kweku Esiedu in Latte, and Ono Edwea Brain. This one says that Obi, the credibility of Mrs. Jane Adukwe Mensah is justified on how she organized the 2020 elections. To me, she did a solid work. It would be wrong to justify her credibility through the witness box. Those who were beaten and died during the NDC demonstration, okay, nobody died, as far as we know. Okay, the NDC could have helped Ghanaians to know whether the EC is credible, but they failed abysmally. Also, John Mahama petition no ato insuum. And regards to Honorable Lawyer Patrick Yauboama, MP of Ekosiisen Central Constituency, Eduanaba Kweku Amponsa, from a better republic, into Eduanaba and on the way. Abba, many thanks for coming through with your thoughts. Let's get on to the phone lines now. Fe Yeni Enkomo, my minute lawyer Nana Eje Bafo Ewa and Kasano, private legal practitioner. Joseph Yadase, or you best sign Edin Komobio, or a private legal practitioner, lawyer Nana Eje Bafo Ewa, Yaneno Inin Komo lawyer, Akwabe Ekosiisen Soni.
Minia, Major also.
Bibi Aboko. Okay. From your knowledge of the law and in your practice, the ruling from the court today, Eba, as a surprise to you, Anna?
Oh, Pacho, I'm as a surprise cry. Pacho, there's a ban on it. Naba.
So, really?
Yes, my may explain me at the beach. I mean, try to meet me up breaking it down. No, it's food in our chance. Wow, before the court, ever my final decision in any matter, piano. Application here, court on your friend interlocutory application. So, applications, yeah, now mostly a discretionary. You can say discretionary, the partial say, and they say court me from prim and a demand. No, you were a money and a mamre, you are a was say, which say in your case, was satisfied into a fatana SSA court, exercise of discretion in your favor.
Yes.
And for each application, what the corner, you were a home a mamre a money. And on your friend or their conditions. If you kind of the standard, and as you kind of say the test, the patriotic say. If you kind of say the principles, and push a petition as an application or what they call for interrogatories, na one mamre or push or more application or what they call for discoveries, na one mamre or and applications what they call European case, and also a one mamre or na AI may say at the risk of sounding a bit prejudicial. AI may say petitioners, na almost say applications from what they call as of right. The patriotic say as of right. A who a mamre any a money ewo into all for it was a what say what satisfy a mamre any a money into share application to reopen a party's case. Well, time what is application by a decline, who are close to case. Answer the party there, who your case are, who be close to case. Not just a wow, would you any I don't talk to a case are why you home. So, say, who here say offer dancing, be view. Who he also say produce any evidence dear view. Would ye what you know? Say young Fred dancing be view. The opposite side I'm Fred dancing be view who case who be dim kunim. So I say in that so Fred dancing be view and also who be dim kunim. As far as you are concerned, who case in the why you pumping at the whole dancing say at the very least, the cause of action what they back court, but you said you can know the rules of evidence was satisfied.
Yes.
And now the opponent say almost so close to case. And to be a doing a court and say, Mungina, for address in na afi moma me addressing the highlights of your address the fire judgment here the emra afi the we see court le makwan necessary open case about what you say
which is a settled practice in law.
Yes. And no emra ne say so court close the case and ya fe na ye be makwan na wa be repeal case na ofu se baby a wanye ni yeno wa ba be ye so ati ase na emom no e ho amamre bi wo ha e was so satisfied and na ma Supreme Court refer to the cases like Poku and Poku no many ade say answer na wo be ba no e was so repeal case about president bi ama na be produce evidence bi ana sa evidence no edikan e was so di be dey identify. Two, I was so to meet here is here Emma case, 3, I was say, what should I say? Sa dance, answer now be close to case, What should share ya? Minimum, well, and nunti, afraid that they say no, Yanko Poya, do more who. It's what would be our what's the record, send a bear, attend training the dead, yɛma kwan na review case the fabetucha but what I say now court no see court no atemu a wo court ni ruling na o ruling ni no o see mamre any amane a ɛwɔ reopening of case no the petitioners no obviously are unsatisfied. In other words, they fail to satisfy the conditions that will warrant exercise of the court's discretion in their favor. The patrol what I say. And you know, the was so be a person what I said the court to me here, or yen kwan paso atawa yen kwan paso for petitioners no affidavit in support of their petition. Neko share arguments are or lawyer in support of the case. Maybe some say edikan one case in mono or share evidence for pa enunti obi opesi a real P case no na obilidi eno ye one. Two, maybe some so say a friend is saying evidence so ochrebia we hear the resolution of the issues before the court. Well, the issues before the court, we say issues in the court, LST, me pa jo me boa.
Sanity.
All the issues, maybe I will say I am first petitioners, identify at the frontier or more personally advance cry or more personally European case, so advance cross or more identifier. How relevant will be for the resolution of the 5 issues before the court. And really two. The third question they say, I will say, at the corner of a person or more backwards, now the European case, and more mobile. A idea there, I'm son of mobile close to a case, almost a share, and the Omer Wulu. And I said, or idea be a mobile moderation share, not Omu Wulu. The patriot I said.
And your honor, no more car, sir. They were under the impression, sir. The Electoral Commission ebe free one witness omo benya akwenya across as a men no and under that impression emo close your case say na omu nim say enya de a woman be step in the boxer anka ebia subpoena application omo ye ntem but they were somehow misled into believing say come what may the woman would come into the box because of representations be another woman no aye earlier.
Obi. Me pacho. Me you are no be the niema me ensa be you are no. Na edikan dem bes me come out here. FM. Se petitioners me kasa. That is a time omo kokko to no. Na omo ankasa omo muagwa ohun siye. Ansa no omo kokko. Because Obi yen need to say them no okay. Court case here, litigation. I was what take the principles. 1, the rules of procedure, and 2, the Evidence Act. And so only I can say, in our part of the world, ours is one of stare decisis. Into all the principles are there are a guiding. The patriarchy are there.
Yes.
And to walk on, I dear Bakua will say 1. And your possible petition respondent, among fair witnesses. The patriarchy are there. 2. And your possible so say, say you have failed to disclose a reasonable cause of action. So I say, and the quarter bra when you opponent so say, oh no, we use now your case. The patriot say,
yes,
such that the way you know, I'm for your case, that is your case, at what you did, one is the patriot, you emphasize your practice. And we are 1. 2, court ruling or the maye on their application for interrogatories. And 2, on their application for discovery of that document. Court can say on granted application, because say they had failed to establish say application and yamanana or more penal irrelevant.
Yes.
It is a court the country will say interrogatories now open mama meno no irrelevant. And answer what the no the answer. And answer documents are open by way of discovery. What the country will say, who will copy? Now the copy no, what the do originally who to be the copy so yeah money so I say yeah mama meno original name court na declare yi sa nyama we are not that so what I say enti se o ka se ma many can affidavit in opposition efe a friend is saying obeba betina that came
yes
it's nobody that so ma betina that came one the man no person ma me no betina that came money year no court na declare culture will say and you're relevant. In other words, as somewhere that you need more year, and somewhere oppressed by many year no prana wa in the resolution of the matter before us. The part what I say. It's a court let the care can say that clearly nasa oppressed with the mammy kwa that came a manico yi sans and croyano. Which I also will say a yadia a befa. The part what I say. Not the Fadia. And yet then I will say, what close to case with the hope say, Ubenya meno amanako adakemu, amanako yi and more court to the caricature will say, and fast about ye being ye manako which means that one Casadu case, you are not even following or appreciating Yama Ecosu in your case.
No, but the other thing is, I remember time review on the interrogatories, na court etna Professor Henrietta Mensah Bonsu eka ebusa in person say Mr. Tatushi Katana said nsemi ye nsema during cross examination ubetimi ebusa, and we all know and lawyer minim say through practice unim say yes, despite evidence I would be court and sometimes through cross examination so no utimi enya some info be from cross examination at the building case Emma case mu eyedu, and we cannot also downplay the impact and the effect of cross examination, especially under these circumstances. Electoral Commission ediju maybe say juma ne ho aba seminti se wonya chairperson e betena box ne mu a through cross examination utimi nya information bi at the back you case no meboa
obi no correct ye wa kan ye no correct. But in this instance, and yes, I'm here. FM. Yanko Section 37 of the Evidence Act. Section 37 of the Evidence Act. A country will say an official duty is deemed to have been regularly performed.
That's the presumption of regularity.
The presumption of regularity. Now, Section 20 of the Evidence Act now, a country will say, wow, who demonstrate say the basis upon which a certain presumption has been made is non-existent. One are bed in the walls. Me patriotia here.
Yes.
Here in to provisions of the Evidence Act. What we say easy, ma'am, a official duty no easy for electoral commission, a official duty no more you.
Yeah.
Now, so that's what the results not to a bon tier. The patrol. So we say it is deemed to be regular until
proven otherwise. Absolutely.
Until proven otherwise. It is a what person who prove it otherwise. The patrol. Jenna obey. Especially when you look at the is it CI 129. Which is CI 129. Who say results now.
Okay, that should be. Oh, cause CI na yede to abe no.
CI na yede.
127. CI 127.
Sorry, 127.
Yeah.
Obi, Yes, what about the and man say electoral commission say all posting results will be with polling station. The battle is sanity.
Sanity.
Oh yeah, representatives of the candidates, you know. Yama obia copy of the results. The battle is sanity. And and run kind of section 137, sorry, section 37 of the Evidence Act says the duty of the youth, you know, being an election, being a public official, is deemed to have been regularly performed there. That's the opposite or rebates our presumption we are. So, Obi, and yet, there was so better and say, my many results now or the 12 one tano. There were different results. Who be? Oh, my country court say all results are one different from the electoral commission. You know the two jobs. Oh, my country. And you know how do you rebut or no statement or the 12 one thing with unknown source when you have the same source? Obi, how do you rebut it? Obi, information now, my minister, so the boy abano. Obi, all my country and says information they want is different from the man and the better one thing. So, oh, dear, what the Babon thing, you can see a sample, and I would buy it. What the sample, then the other in our way. So I say, and to Obi, Mamma dear, when we are Juma, when you look at the Evidence Act, like I quoted, it is for the petitioners to rebut. So person rebut here, the patrol, and yeah, after Mamma on what near rebut, especially when the source documenter or the declare results will be, also friend P or no, no. I will see any papa no, and now person better dance him can want that. Can want them. Supreme Court and they say, Debbie, dear, why you name dear? Sebi. In fact, Oklahoma country and say results are or the body different. Into another can make a day. So, secondly, witness are offering no. Was 16 of the summary of the report summary of the results from the regions, you know. It would 13 or sign here. That's what I say. 3 now, I cannot. One sign about 3 no crano, and Francis I be day Emma. It is a mamma, so person quite a cam now only batty. So, on only duty, no, why, you know, the patrol. Don't forget, say, the Electoral Commission is the creation of statutes. The patrol, and so the statutes that govern is, you know, any who see I govern the conduct of the elections, you know, what shall advance at each turn, a bet Chesa Mamma, the Juma, Wayana, Onye, Sa advance, you know, and only at the polling station, the pink sheet, at the collation center, the former, the collated result. At the regional level, the summary of the reports from the regions. And at the head office, you know, and only form 13, you know, and only the evidence and rano ediginal or extra prima facie evidence say easy why the Juma Onye.
I get your point, but said you know wow kana article 63.9 Emma you know the CIA was say oh yeah I just said the result is gazetted any ababe act na beyemra that is the declaration no assume say no bentin more than 50% ababa beyemra but that declaration is based on a source document which is very critical in this case you know so obviously CI 127 that source document a presidential declaration form 13 the form 13 no ababe disputed because you see no PW I think PW2 yes PW2 petition the witness number 2 Ekpesa White Eka say Form 13 Justice Tokonu editre no in open court. Which form we all believe say a free Jean Mensa witness statement mo a the can as exhibit. Or the chair no or say or no Form 13 template away in CI 127 no. And yes, sanity. How do we resolve this issue? Because mind you, sir, so Form 13 a source document for the presidential declaration. How do we resolve such an issue?
The patcho. And no, say or CI say
CI 127, yes.
Okay. Patcho says CI 127 and then govern the conduct of the election.
Of the elections, absolutely.
And now, what is you know, and yet the walk court and yet the CI in the okay. The patcho. It is Supreme Court to interpret that law. The patcho say interpreting the law no. Say easy for say omunya dance ya. Na sa court re find they say CI ana ewo omani no ana so omuhu ye no. Wo say CI no enye sa na tia. E wo go against the easy. E wo go against the easy nti na wo here no to come and do the witness box.
Okay, the meaning say for now no the court can look at CI 127. Now omashe template na woman no e dey compare what they have as the exhibit from Jean Mensa. Say ebro the court can then take a decision.
Yes, but what we say papa friend saying Dr. Professor White.
Yes.
In the witness box.
That's all right. Yes.
So it forms part of the evidence before the court.
Absolutely. Absolutely.
Good. Now, CI 127, no, the patrol say a You don't go to the witness box to testify about law.
Yes.
But you testify on fact.
Yes.
Yes. And then the court will interpret the law. The patrol it is a court, you know, the evidence before it. Now we submit it say form it does not form part of the law. The patrol Then the court will rule on it. Do you need Jean Mensa from what I've said? You don't.
But won't it serve you now better? Say Jean Mensa babeka say okay, more say form no enye correct. Form am use yendi CI 127 in so any. I am telling the court in all confidence the same form. I don't know Jean Beyes ana emwa.
Me pacho said the no attach the witness statement no. Yeah, the chair petitioners no witness no me boa in the witness box. Emma ya no. When ya no.
We ya no.
Yeah, no. It formed part of the record of the court.
FM.
In the court, now if a submission is made to the court, I want the better to know, and they'll come to their own conclusions. Sure.
Okay.
From the Supreme Court decision in the 2013 petition, say court challenge election petitioner. So challenge the results of an election. It now seems to appear say a proper challenge should be on the numbers are supported by the pink sheets, right? Then say say form being set.
Yes.
Because form 13 I will come wash away. Right? Form 13 no. And also prano I want a source document too. The source document any pink sheet
Any pink sheet from polling stations, no?
From polling stations, It's gonna make us say no matter what. So okay 2013 petition the petitioners no case say your pink sheet FM. Oka Hani Hessiania, there is overvoting. What if you want on Asempa FA? So I say, we assume see and signing, and you know, say, and also who are no lena, a who's in so I say,
yes.
Now, the decision of the court it flow from contest now. It now appears to say the most viable petition will be one that is challenging the figures at the polling station, because the court might not be ready, right, to cancel the results from the elections on the basis of the form we are now we. That is how, based on the 2013 petition, who gave the mind of the court.
Lawyer, mami nintem na yenhwe we, because here ka say ya mensaka two applications as CCR petitioner no aye. Number one aye application for review of the ruling of 11th February 2021 in respect of notification to court by respondents that they would not be calling witnesses. You know, into my filing application of review of that decision. Now court na Asha said the court to be moved on Thursday, 18th day of February 2021 at 9:30. In the Thursday, no court na better review application with him say about review judges mienu eba beka judges nso a wo ho no ho. But say me share affidavit in support of sa application we na. Be 6 paragraphs pe enti I, John Dramani Mahama of house number blah blah blah. I am petitioner and applicant herein and over 2 and say at the hearing of this application I shall through my counsel seek leave of this honorable court to refer to all processes filed in this case as if same were reproduced here in extenso and sworn to by me on oath. Baby here pa the paragraph 4 reason why I'm open review or say in respect of the application for review of the said decision of the Supreme Court delivered on 11th February 2021, I am advised by counsel and verily believe that the court made fundamental errors of law, including the ruling being per incurium of statute and previous decisions of the Supreme Court, and that these fundamental errors have occasioned a miscarriage of justice against me, as are set out in the statement of case herewith attached. Inti, omo statement of case nenso ayeden the account the ruling court nema on the 11th. Then where you ruling on time easy lawyer ka say nyadi omo be from witness no court no egitumu and no na John Mahama say court no a mistake ewo emrem inti almost say a fundamental error of law, including the ruling being per incurium of statute. Not just a say mistake be aba ewo eho. O jene saying Thursday court net na review application is so we are now the second application so my file and also media tum inti review the no who saying
say almost say there's a fundamental error.
Yes.
The court decision. It was not in accordance with law.
Yes.
You know, Oman Chemrebi in the Omuni. So I can say. And essence of court now Chemrebi no be you know. Has okay a man to be petitioner no. Oh yeah. Ekosiisen on Asempa FA. So the another you're all right. So now say what share there's a trend after almost every decision of the court right, with the exception of the Yurakutam Paukasa or strike out part of the metal witness statement. The Duana or Casa or strike out no. Emu kakre bi na court no play ana Yura a civil ketiaso de court no a grantee strike portions out. Apart from just these two decisions, it appears that almost every decision they apply for review of it. So I say,
yes,
making it as though the review no it is appeal. That's another thing. What I say? Yen shed your call to the Becker. Yen shed your call to the Becker.
On Thursday. Into that's
Thursday.
the review application. And as because Osho almost second application and so and no year motion on notice for stay of proceedings. Motion on notice for stay of proceedings. And also no a court no ama won Thursday 18th February. Se court no ebetna sa eno nso eso. Na reasons are omodi pe stay no because unim se court na kase directive omo maaye se parties nyina file omo written submissions by ochina no that directive still holds in the ochina omo file na Thursday omo mra MMA oral submission of the highlight of sa your friend is saying written submissions omo file you know. John Dramani Mahama say they make the point say there is an application for review. In the Omar referred to review application I can earlier no. And Omoka say I am advised by counsel and verily believe that the review is likely to succeed as the ruling of the court is manifestly in error. In the meantime, certain orders in respect of filing of closing addresses were made by the court on 11th February 2021. For us to have to file closing addresses when there is a pending issue to be determined in the review application about whether or not my lawyers would cross-examine the chairperson of the first respondent would cause irreparable harm to the conduct of my case. Since we expect to be able to cross-examine the chairperson of first respondent, all the above constitute exceptional circumstances on the basis of which I respectfully seek orders of the court staying the proceedings in this case till the termination of the review application. Not to stay proceedings would create the impression that the review application has been predetermined. No prejudice will be caused to the respondent by the grant of this application. Omo pese court no stay proceedings. They will not have to even file omo closing address until review application is heard on Thursday. Closing address, and so you see omo filing on Wednesday. What does this mean, lawyer?
The stay of proceedings. Yeah. Court no. Say the taking and say court now order say you be and now file the process be now say the making order for stay of proceedings the be anywhere assume quite say any quite say oh yes and until we practitioner now say court ma say order say file the address and now say court ma order say we take step be now say why appeal against the decision and now say why apply for review to say the petitioners now Asempa FM person court no the cost were to an amobino now the motion for stay of proceedings aba so now the motion for stay of proceedings bar to say the more canon so we demonstrate to say there is some exceptional circumstance in the court in granting. So, in the son of stay of proceedings here.
Okay.
Now, we know the application about say the stay of proceedings and the next proceedings. No, I see a will say, a bina say court no and stay will be suffer any prejudice beyond. So, I say,
but the thing no really necessity no. It was said by close of day or Wednesday. Omo file written submissions. So we share application motion for stay of proceedings now. Court this one bet now so Thursday. And the reason Omama for the stay and they say omuntimi file omo written submission when they believe say omo review application no would be successful. And obema won kwam omo cross examine Jean Mensa. What would happen? Would they still have to go ahead?
Let me explain One. I'm saying Mama Quina Mama Becca Perry. One motion for stay and application for stay. Answer court to be a bit Yana and one pretty as a stay. The patriotic say. what we support to be the application, yeah, not stay, it will pretty as a stay.
Maybe also it operates as a stay, and it doesn't operate.
It operates as a stay.
And once our filing,
there's a school of thought. There's a school of thought. Once our filing, mostly, in practice, say, file it then becomes a justification for the step that you haven't taken. As to whether or not said the court will grant it, is another thing, because what we say in practice, I may explain you in for the filing of written addresses, right, or the default of it, will not stop the court from proceeding to give its judgment.
Okay. Okay.
The court catcher will say, file addresses. Now, what my date say, remember my judgment date.
Yes.
Now, say one file, that will not stop the court from giving its judgment. If we say court on the address, who address the court, the facts, right,
and the law.
And the law. So what I say, the facts and the law. The facts, and then a court to tear jam or tear during the hearing, until court, or your witness to the facts as they played out in the courtroom into what it be. So what I say, and Ranon Sono, and will court to Kukumu. So what I say, into all your addresses,
okay,
to deliver a judgment. You help yourself by making sure you file an address. Into address, in practice.
Yes.
It is a one final address. The court can go ahead and give its judgment. Secondly, say, prior to the address, so not say what file address. Sorry, prior to the judgment, no one file address. Now there is a development. The CM could see any pebiano as the moon to say the opposite of Muya. Well, who bet me a file a supplementary address? Me patriote say, enti was send your message actually me. You are beside say, the court no and grantee stay of proceedings. Me patriote injury being na petitioners never suffer. Supreme Court they make it a decision. Me patriote say, but send your message actually me say ya on it. Me patriote say,
yes.
Now, the other things we say, what we say, almost the application as a Thursday, and almost the stay of proceedings as a Thursday. So there's the possibility the court will be the application on Thursday. To take application on Thursday now, the motion for stay will become moot and now redundant. That is so court now striking out.
No, me person me clarity on this. Sisi anoma file stay of proceedings no enne. Court na mo date say Thursday na otna so eties asem no. Meanwhile, ochna e was almost file or written submissions. Would they be right to say because of stay na ya motion na ya filing inti ya written submissions ya mfanko, because I remember say in this same trial there was a time a court ne share say omon file omon witness statement. At the time na petitioner no a file application for review. And almost sign file application for stay. But court no was livid. Say we file applications now. They don't on their own operate as a stay on the proceedings. In the court okay, it was just the review application.
It was just the review application. Now, in practice, so who apply for stay, pending the determination of the application in practice, it operates as a stay.
Okay. It is here no file stay, they can decide not to file the written submission or chana.
And I don't think I'm wrong. I think that is the position of the practice.
Okay. Mate, we would see what happens on Thursday, God willing.
Yes, but so we share the trend, man. So we a motion for review of court decisions Oma petitioners, Oma respondents, AOP case.
Yeah.
Okay. And so we are likely to also have a review. Well, what's your trend now? If the trend is anything to go by, we are likely to also have a motion for review of the decision
of any ruling,
of any ruling.
Yeah.
And so you embrace your hope for that.
But ebi aka, I got a quote from a friend, and that quote I can say, with your leave, maybe I would read it, or say, in the interest of society as a whole, litigation must come to an end. And I don't know where the end and when that end would be, because as much as possible, say nipa ni who any legal opening the petitioner will take advantage.
Yes, what was say? So court there more. There was so judge the arguing. So I say, and opponent so I will need a case and so so no city. So we share petitioners in case. We share petitioners in a lawyer. Petitioner and a lawyer. And yes. He leans towards this kind of practice. If I thought I say, what kind of time even when you were standing trial, applications upon applications from the competence of the court, the jurisdiction of the court, and what I say, honestly, style or no.
Yeah.
So I say, as to whether or not it is proper, it is for him to judge. But honestly, style. But ultimately, like the tester said, litigation must come to
an end. James Kwabena Fese Obi remind lawyer Bafwe Wua that there is another school of thought that holds that the filing of the application for stay doesn't constitute a stay per se unless and until it is granted by the court. Into another school of thought in so adjoin on, right?
But and, the American is the dominant school of thought.
Okay.
The only application a court, the only order a court na making, and they say young file addresses. Now, say me file address, right? Now me file motion for stay now. What am I staying?
Yeah, it makes sense.
And so that is the dominant practice you need. Because it says for filing stay now, for file address now, the stay no moot. It is what you say. The application for review, right, will change a NEMA for him, such that say young state proceedings or best suffer prejudice. Now I file it for stay, right? Now say cash own filing way now address now. It defeated the motion for stay, and it will defeat the very purpose of even the ruling that will come. So I say, it's a motion for stay in the in my humble opinion, right, it falls within the doctrine, the practice to say it will operate as a stay in this instance. That is my humble opinion. But the court, is the master of its own.
Is the master of its own rules.
Yes.
Okay. Lawyer Nana Eje Bafo Ewa my nase nafi yeni enkomo. How about this point, sir? Both decisions relative to two school of thoughts, James Kwabena said both decisions are of cognate court, and it is yet to be settled by the Supreme Court. And it may be the Supreme Court might take advantage and on Thursday, settle this whole thing, because who shared the body language of the Chief Justice? They were in no mood to entertain any way of their directives, say, or file it, or more written submissions by close of day tomorrow. As the court was bent on, and there was some repeatee, into whether the filing of a stay of proceedings would actually act at stay. And as the court would have to grant that. Maybe the Supreme Court may decide on Thursday. For
more example, before the case of Magna Transport, right? The Republic versus High Court, ex parte Magna Transport, Vodafone, interested party. Now the position now want to say, who call for stay of proceedings, who call court of appeal. Nanka kanenu puno so who call court of appeal. Now what with the copy of the letter, with the copy of the application. No actual letter come on. Now the call high court, there be assembly pending. No actual said there is a motion for state pending at the court of appeal.
Okay.
And, they should hold on with the proceedings. The practice was that the court will stay proceedings.
Okay.
Yeah. And so, just as we have come to say,
the example you just gave, the appeals court and high court, which in the hierarchy of courts, a lower court compared to the Supreme Court.
No, the example I gave is an example from practice.
Okay.
And practice is part of the settled practice, is part of the canons by which justice is delivered in the country. So I say, going by settled practice, and I'm sure there will be a lot of cases on this. I cannot readily remember some of them.
Okay.
But I'm saying that even going by settled practice, it will create as a stay. Otherwise, the application will be moot.
Lawyer, my nasi, bibi any ebesi di nkomo bio. Why? Yeah, that's a pa. Until lawyer Nana Eje Bafo Ewa, a private legal practitioner, Namoten and Kano 34 minutes after 3. Ekosiisen in Wasempa 94.7 FM. I've just been told by the production team, say, WhatsApp line no assessor me pamochao inti uwo pen na fa paper netro ye new WhatsApp line inti Ekosiisen new WhatsApp line a mebe buboyi. But modern say obetro atoho amame na o messages ni na wetimi dia fa so abrand ya kan amount 0548 955 947 messages is sube in premiensa 0548 955 947 Mitimubio 0548 955 947. For the last time, 0548 955 947. Indeed, Ekosiisen WhatsApp line for front and but more say ode o messages ni nyina be fa so abrain na ya come some messages already coming through. He say Anthony Yabo say Ghanaians must tell NDC that they are wasting the time of Ghanaians and wasting money as well. We say Daniel Ejekuma says the lawyers should give us the non-lawyers a break. Proud to a decision from the bench, they will not express their opinions but find their mouth immediately after the decision. But Sunday was say, Daniel, proud to the decision, was Oko can be because proud to the decision, the matter is still sub judice. And won't penny for him. And Oko can be and sure now prejudice the decision of the court. And Nuntina, na lawyers Nankasa proud to the decision. But after the decision, the court Nankasa Jitum say you can critique as it were, the decision. In TNTS, yes, sir. Kwame Mafo says elections are won at the polling stations. Dennis Abuaje says you cannot make malicious, unfounded, and unwarranted allegations in the apex court and expect the judges to rule in your favor. Okay, we say we don't go to court to speak grammar, only fact and evidence. That's from Thomas Opoku. Thomas Opoku. And also they are and still picking the views of some private legal practitioners. Meyanko Gempa ain't law lecturer Bakon Gempa Dr. Kweku Ajeman Budu. Dr. Kweku Ajeman Budu, or a lawyer, law lecturer and head of law centers. Our Gempa Faculty of Law, or a founder, executive director of the Justice Foundation Ghana. Yaneno ini enkomoni anya na jenche and doc yamu akwa be Ekosiisen so ni.
Bejo so minia.
Na apomu ye de.
Nyame adom me ho yɛ paa na I hope some of more.
Nyame adom yɛn nso yɛn ho yɛ papaapa. Ma yɛnhwɛ na menye wadwen kyerɛ wɔ saa asɛm yi kora ansa na yɛaba ruling of the court no ɛso. And yɛnim sɛ school of thought no ɛdɔɔso around this. And the petitioner are filing a motion for stay of proceedings pending the court hearing or review application. Coincidentally, 2 motions have been scheduled for Thursday, 18th February. By a name, sir, or close of day or no, court nasha so munyina file or more written submissions. What does this mean? With stay of proceedings in the adeno, should the petitioner still go ahead and file or file it?
So, Sir Mukaya, earlier on in the proceedings before the court, court directions need to the parties. I think it was at the time where they were supposed to file
witness statements.
Witness statements,
Yeah.
precisely.
Yeah.
And one of the arguments petitioner, no lawyer, Mickey, was that they didn't file those witness statements because no Mujidi says so. I'm go ahead to file the witness statement. The other parties, will end up using it against them when they themselves were challenging or suggesting, say, the ruling that the court had given on the interrogatories. They were challenging it.
Mhm.
And so it would be as though, in one breath, challenge court because interrogatories are important in order to enable you fashion your witness statement. But in another sense, you are going ahead to comply with the court order. So that was what happened. And Samokaya court, clearly suggested that they could still go ahead to do that because it was possible that even after they complied with court directions to file a witness statement, they would, assuming the application for review of interrogatories, the ruling on the interrogatories, assuming that it was granted, they would have an opportunity to file a supplementary witness statement. So it doesn't matter whether they filed or not. So, that happened during that particular point in time.
Yeah, Mekai. I think that the only difference, and it's at the time, was a man file motion for stay of proceedings.
Yes.
But we no file motion for stay of proceedings. Should they still go ahead and file their written submissions? And I said, then because the court was clear, so I'm file it.
Precisely. I think once the court has given its directions what the directions will stand. And you rightly pointed out and so said the Honorable Chief Justice today reiterated the point that the parties are to file their written addresses by Ochna. And then on Thursday, parties will highlight on those written addresses. As it stands right now, I believe, sir, the status quo before the court is that parties are not expected to file their written addresses, despite the fact that there has been a motion that has been brought before the court. But obviously, we would have to wait for Thursday since the stay of proceedings motion, is scheduled to be heard on Thursday, as well as the the review application that they brought in relation to 11th February ruling. That will also is scheduled to be heard on Thursday. So I think that all this discussion I here having, we should just wait to see what happens on Thursday. Because I'll give you another example. Typically, what the case called the opponent, file, let's say preliminary objection now. The court will have to determine that preliminary objection because, for instance, that preliminary objection may go to the heart of the case. Say, for instance, a whole need pine crash and audio near corner backwards because we need capacity and now we need any course of action in the first place. But what the court said was that ruling on preliminary legal objection, the first and second respondents filing, they would deal or give its ruling on that matter and incorporate it in the judgment of the court. But under normal circumstances, it should have been dealt with right at that point so that if it was determined any course of action to bring the matter in the first place, then it would have been dismissed. But we saw that it's being essentially will be part of the judgment that the court will give at the end of the day. That's why some of these discussions, we should put a hold on it and actually see what transpires in the Supreme Court, And Thursday,
Yeah. Yeah, I get your point. But to the ruling itself, and the petitioners, no, obviously, are not happy. And so, what your spokesperson or Kasaya at the press conference, and then another media briefing immediately after the court settled, no, or Kasa, this ruling, no, shows, say, the bench had a predetermined mindset even before say argument maybe be a crab no my dada. It tells you how unhappy they are about any ruling, no, and how an in fact Omasan aka and say the judges no add in more appreciation of the laws and the cases petitioner no at the year or more argument, no. That's what saying.
And see, unfortunately, no, I mean, I can't comment on what the petitioners or the spokesperson, let me put it that way, of petitioners now are saying out of court in relation to statements regarding the justices of the Supreme Court and other Supreme Court, because I believe, sir, the matter is still before the Supreme Court, and we want to stay away from statements that will be prejudicial or anything of that sort. But the point that we need to also drive home, no, is that people are entitled to their opinions. And I mean, we know that in court, no, the court decides any application that comes before it on the basis of the merits of the application. No. Arguments are open, Mickey, and then whatever support any cases that there be a court, no, and I say other courts that decide court to the heart of the case, no. Those are what you present to the court. Now, court, no, on the basis of the arguments that have been made, you know, decide one way or the other. I mean, people can be dissatisfied with decisions by courts, but I believe, sir, we should all be measured in the statements that we make, because you won't be done. In 2013 election petition, no, Manfobi statements ended up before the Supreme Court contempt, as we are aware of it. Mm-hmm. That's why I don't want to delve into what the petitioner may have said in relation to what had happened and all that, because I mean, per se, very prejudicial or anything of that sort.
In fact and in law, any ruling of the Supreme Court, yes, I mean, himself, we are officer of the court, and you are minded to want to, defend the image of the court, any BBR, but in fact and in law, any decision or not right, and as you expected something different.
So, as someone now that court name and pay, a application, petition, a year man Penida, His Excellency John Government Mahama, at the two courts name say, Nano ruling courts no ma, say, respondents, electoral commission, and man Penny, His Excellency Nana Danko Akufuado, would to me, one bramu, say, omobe to me a close case, no, and nonty. Petitioner no normal quine every court no ho so no metinia be case to reopen application and normal make it some reopen case. So now manya quine afre electoral commission chairperson Mrs. Mensa. I'm a naba be dia dance ya momo. Now way na no joada no petitioner no any respondents no I make you almost arguments in support of almost respective positions. And court adjourned to an end, and the ruling, the court essentially dismissed the application of the petitioner. Mm-hmm. But one of the most important points in the ruling, the person drink argument petitioner make here on the basis of conclusive presumption, say on the basis of Section 26 of the Evidence Act, I trust so be a BB, not on the basis of the INO. Another person rely on first mentioned person to believe in the truth of that person or act on that to the detriment on your corner or making that statement yes he's conclusively presumed to have there's a conclusive presumption said and assembly now said petitioner was still arguing. Sir, by virtue of the fact, sir, electoral commission, a filing, and also the filing of a witness statement during the case management stage. At the time, a court director almost said they should file that witness statement if they had any. No. At that point, they had elected to adduce evidence. Just say no more much. Just say omobedi adanse here case no. And none of petition make say on the basis of Section 26, of Evidence Act. To mean Daniel Mohu once elected somebody adanse here to turn around and say in the adanse. And in to say respondents make a counter argument. Say on the basis of Order 38 Rule 3E5 of CI 87, that is the High Court Civil Procedure Amendment Rules. A man who can say Ubetina file a dance carta now witness statement, but Uber says I won't fair witness Now in that situation and in that circumstances, and Manoso Maho Quine said the other party, to me are introducing a dance carta now. The first party no file and so man fair on your court or carta na man be the The other party no be to me a secure leave of the court say omobe tender in that adance carta witness statement into evidence because you say adance carta will be assigned there. Unless say on your court now throw that statement here, the number be see adaka no as well amaya adopt this dance carta it is not considered evidence.
Yes.
And here evidence the year before the court. Inti and non court also can't say and in its decision or in its ruling say it seems as if the petitioner repeated the same argument or make here in relation to the other issue, the issue of the parties refused closing their case. Claimant said they've closed their case, or certain said they've closed their case. But in the court opinion, another decision of the court was that the mere filing, and I said the fact that wako filing a dance carta no, and just say what Jawadjin say at all costs to be a dance here, now be fair dance farm or mobile be a dance. Inti and non so na court can say petitioner closing the case close your case if he said no mujidi say and I say because say na easy electoral commission I file a dance carta and yet nunti and no close your case. No more close your case, if say. No more say on the basis of a dance for no more from more, a more baby a dance more introducing evidence in the case. Now make your case. Into no more close your case at that particular point in time. And according to the course can say you succeed on the strength of your own case. Now also settled practice. Say and na court ebema who coin ama saying be case idea discretion, just a court discretion, which should be exercised only sparingly. Just a and also court granted application to open cases. Now also court OTA application this I was also balancing a number of things. There was almost maybe say a koya and answer maybe almost shema. I bet indeed there was a to me who coin. I'll be okay. Ebino say, almost share ABR. Lawyer said they will share conduct the case, and also what the justice of the case demands. Almost share evidence. If Anka will present earlier on, and KBA Beboa case, and I say ABR Nanka or who finds so which now present this evidence, previously, almost share. The relevance and the materiality of that evidence, whether a wow case, but also importantly, whether that evidence, and prejudice the other party, just and the other party, if you bet me, I can say, because say your court trial be say, and I say court cases say now, parties are supposed to disclose essentially almost evidence or more discovery what process will be himself saying saying sooner way because now you don't take anybody by surprise because litigation is not supposed to be surprise. There shouldn't be ambush in litigation and things of that sort. And a court in sign can say petitioner any evidence or fresh evidence be a more person more juicy because essentially empire no more court no more who crime more sign be or more case Omo bon sampaye and I say omo pray courts no to give them that opportunity no. Sana courts no more opportunity now. Omo to me I call it fresh evidence. Now there's a standard and so that under the law no you have to meet. When people say call it fresh evidence, now no na court need to say on the basis of application now petitioner no making no petitioner need to mean convince court and say omo meeti that threshold not to adduce fresh evidence. Inti and no na ruling of the court. Now me say say a certified true copy of the ruling now. You bet me a pipe mu ye mama for say.
I think it's fair. Inti the ABSC and say yeah the best see, and then we'll talk again, God willing, on Thursday, depending on how court ruling ebekono yebesan so di nkomobio me da se papa se wenyamre amayen yebesan di nkomobio doc me da se pa nyame insurance doctor Kweku Ajeman Budu a lawyer or say a law lecturer and head of law centers our Gempa Faculty of Law ono also na founder and executive director Emma the Justice Foundation Ghana. And I'm so then adventure eba yen komo a yedi